and I have the really great honor to present Ted, our speaker for today, Ted Lim. And we just met in Paris at the ICC mediation competition last week. For everybody who doesn't know this competition, it's a competition that the ICC is running every year. And there are people from all over the world, 60 universities and students who compete against each other in terms of mediation, parties being parties in mediation. So they learn at the same time about mediation, advocacy, the process of mediation, and so on. And we have professionals from all over the world who are judging the competition, but also be there as mediators. And so, yeah, we met there, Ted, and I heard from you a very interesting comment to the students, which intrigued me also, because you said half of my practice is as a mediator, and I guess I forgot about the numbers, but I heard there is a lot of mediations going on in your sphere. And half of the cases that I'm involved with mediation, I'm actually a lawyer sitting at the table with my clients. And I think that's a very interesting perspective to have this. And there is not a lot of people, Ted, that I know that do this, the two roles, to be like in kind of in the same 50-50 percentage, to be a mediator and to be with parties in a mediation. So, both of the perspectives, and it would be, yeah, also nice. I think we're talking about the Singapore Convention today, but maybe you can share a little insights about that as well, about your practice. Um, just a few words about you, but I would love you to present yourself, because there is so much to say. But Ted Lim is a board, or in the board of the Singapore Mediation Center, also from the board of the IMI. You all, I guess, know the IMI. And as I said, a lawyer, mediator, and based in Singapore. And when we talk here in this webinars, but also in our trainings, we always talk about Singapore, actually, Ted, for different reasons. First of all, and maybe you will tell us if this is right. We think that Singapore is one of the epicenter of mediation, of what I would call also modern mediation. It's not a place where mediation, in our view, and please correct us and tell us a little bit about it, where mediation was always going on to this extent. But for the last year, it really picked up. And then, of course, the Singapore Mediation Convention. And that is also our topic today, that of course we discuss that in our trainings, in our communities. And yeah, there is a lot of information around that. And we are so happy that you took the time to be here with us. And yeah, I hand over to you, Ted.
Wow, thanks, Andrea. That was a lovely, lovely introduction, and it was good fun, right? Didn't we have that fun in Paris as well,
Yes.
exchanging ideas? Yeah, so you're right. Let me start with the fact that I started my professional life as a lawyer, and while in university, mediation wasn't taught during my time. That was like 10,000 years ago. But then the course that I took was a litigation advocacy course. And I thought such a wonderful course. I thought, it was the craft of what lawyers should do in court. And very quickly in practice, I did what I thought was the best job, of going to court, presenting cases, and so on. Um, but I think it's with all learning that after a while you find yourself gravitating towards something that might look rather different from your original first love. And I thought after having practiced for about 10 years, I thought maybe it might be arbitration because arbitration offers that somewhat more casual, more flexible process without the um, hard, strict rules that one applies to when you are litigating in court. And in those days, of course, when you think back about maybe 30 years ago, arbitration, even in institutions, did not contain the whole array, the whole complexity of what you will find in today's commercial arbitration scene. In today's arbitration rules, you will find all sorts of different processes, which almost reflects the gravity in which arbitration has moved very much closer to litigation than towards a bespoke kind of quick resolution of disputes through appointing someone who's a subject matter expert who can issue a decision quickly. In fact, in my jurisdiction, the joke sometimes is far better to go to the courts, because you go to the high court, there's an internal requirement from the time you start your case that the court will issue a judgment within 18 months. If you go to a commercial arbitration, you might 2 years down the road still be waiting for a date for your evidential hearing. But back to my story, right? Because it was about maybe 15 years down when I first started practice that mediation started appearing, commercial mediation started appearing in Singapore, because the then Chief Justice decided that they will bring back, that there must be a way to bring back mediation to Singapore, because in the views of the Chief Justice, and I suppose for many of the judges here, as well as for the people involved in law, mediation has its roots partly, and some might argue mainly, in the Asian domain. And it's not unusual to look back in history and find that for many, many of the disputes that you see in many parts of Asia, the way to resolve it has always been through a process where a trusted senior person comes into the scene, facilitates the discussion, and through the wisdom of the collective, a resolution is found. So commercial mediation arrived in Singapore probably about 25 years ago. And initially, it was done through the courts. Courts had court annex mediation. In the lower cases, the judges, certainly not the trial judges, but there were a pool of judges who would facilitate a discussion and also facilitate the mediation. In the High Court, the cases where parties are invited, encouraged to pursue mediation. And if they do, it would look very much like the commercial mediations we do have today. But that's how I started my journey. And so it does answer that question, Andrea, how I became having two streams of practice. And one relates to my stream as a neutral, where I am appointed as a mediator from time to time. And more rarely, because I don't really sort of move in that space too much, but from time to time, I get appointed as an arbitrator or co-arbitrator, or as a member of a dispute panel. That stream to me started close to maybe about 22, 23 years ago, after I got my certification and all that. But I never stopped practice. And so what I found is that, at least in my space, having that parallel journey, one in which I act as lawyer and counsel for parties going to mediation, and having then to apply all the art of negotiation, apply the strategies, the principles of negotiation, is so interesting and so rich. And then, once you've done that, and instead of sitting at the side of the table, you sit at the head of the table and facilitate a discussion. The way that my mind would work is it's almost like I can see the thought bubbles of the parties who are appearing before me as a mediator, because half the time I'm sitting there, and the other half I'm sitting here. The advantage is that you are able to very quickly appreciate, even before they might do a certain thing, that's probably what they're going to do. The bane, the not so good part, I would say, is that as counsel for a party, I find myself, unable to shut down the part of my brain that keeps evaluating the mediator. So it will be in my mind like, no, you shouldn't be doing that. You should be doing this, right? Or no, you should now come and help parties do this or that. And it's a bane, because if I don't control myself, I end up being very critical of most of the mediators that I appear before, and that's not my job. Right? My job is to use the mediator who's been appointed and find a good outcome for the client. But that's the bane, because I suppose whenever you find yourself, I suppose, massively invested in any particular discipline or learning or thinking, it's very hard to shut down that part of the brain to say, what's gold standard for any particular area of work. And if you keep to that gold standard, you're constantly judging people who are applying those skill sets in front of you and asking the question, what did that person do well? What could that person have done better? So those are the kinds of things that sometimes I find very irritating about myself coming in as counsel, and even sitting in the other hand as a mediator, sometimes wanting almost to tell the parties as a representative of the client, you need to negotiate harder, or you need to do this or that. Those are the difficulties. But it makes for a very rich and exciting and interesting practice, I must say. So I found that this balance of doing mediation as a neutral, as a mediator, as well as doing mediation as a lawyer, works extremely well for me. And I think it's unlikely I'll give one or the other up for many, many, many years to go. Okay, anyway, I think that maybe that's not what you're all here to listen to, but that's pretty much my background. I see good friends in the mix, of course, Nicholas, and I see Beatrice as well, which is all of us were just in Paris together. It's lovely to see you. The subject matter of our discussion today is really about well, commercial mediation and how the Singapore Convention is relevant or not. And I thought what I might do is, for some of us who maybe are not particularly conversant or have not really thought too much about the Singapore Convention on Mediation, that you might find this discussion sufficient to help you maybe have a view on where some of the rest of the world is headed towards in the mediation landscape, right? And it might help you to understand better why there are so many mediators who are so pro Singapore Convention, and why are there yet also quite a number of mediators who are very anti or anti Singapore Convention. It comes with the territory, but I think maybe a discussion today will help us and help all of us to share some ideas and maybe give our thoughts in the course of today. I think the format is going to be quite straightforward. For me, it's 5:15 now. We want to do about half an hour of this, and then we stop, and then let's open up for I won't call it Q&A, but let's open up for a discussion, and lovely to hear everyone's comments and thoughts about the subject of the Singapore Convention. What do you think it means to you? Does it matter in your area of practice? Should it matter? And if it doesn't matter, why not? If it does matter, how do you see it affecting you moving into the future? Let me get a set of slides out there just to help me move this along. And Andrea, I think that from your reaction, you can see the slide on screen, right? Okay, great. So commercial mediation and Singapore Convention, but just so that we are all aligned, commercial mediation, therefore, by virtue of its term, is often it refers to mediation of commercial cases on a professional and paid basis, right? We're not talking about community mediation. We are not talking about family mediation. We're not even talking about, for some of us, the mediations done at the independent accountability mechanisms, various banks around the world, including the World Bank, involving ESG disputes. We're talking about typically cases where there's a breach of contract or there is some commercial element to the case, where parties either have gone to court or haven't, or gone into arbitration or not yet. And along the way, either the lawyers or the parties decide this would be a right time to move into mediation to try and find a facilitated, negotiated outcome, right? And that's the kind of space we want to be thinking about. And how does the Singapore Convention matter in that space, in the commercial mediation landscape? A quick agenda, right? Just so that, we have a roadmap for ourselves. Maybe we start with the why question, and then we deal with the what question. after we deal with the why and the what, let's quickly think about what are the consequences for those of us who practice commercial mediation. And then I will reflect on the arguments for and against it, which I've heard from practitioners around the world. And then I'll land and close with my own personal reflections, which might reflect some of the personal reflections some of you may actually have. So we'll start with why the need for the convention. And I think when you look at the why, it has its roots in a lot of surveys done pre-Singapore Convention, right? And here's one that was done a long time ago, 2014, by the International Mediation Institute. The question asked was to the respondents, many of whom are either in-house counsel or senior corporate managers. The question asked is, would you be more likely to mediate a dispute with a party from another country if you knew that that country ratified a convention and therefore any settlement could easily be enforced? The question itself suggests that the party must come from another country that ratified the convention. But as you will subsequently see, the Singapore Convention does not operate on the basis that the parties need to be from a party that has ratified the convention, right? So park that thought in your mind. But the way this question is asked, of course, is not reflective of what the convention eventually became, right? But what is important in this survey is that people actually said yes. A majority said more likely than not, we will be happy to mediate a dispute if we knew that that party came from a country that ratified a convention on the enforcement of mediated settlement agreement, right? And it's a very low percentage, 7.1, that says no, absolutely no relevance. We don't really care. It would not change our decision whether or not to mediate. Another survey by Stacey Strong. And important survey actually, and if you have a chance to read her paper, this paper to me I thought was very seminal because the paper allows us to appreciate the whole spectrum of reasons why the US delegates decided to how do you say, to put forward the notion that the working group 2 should seriously work on a convention that allows the enforcement of mediated settlement agreement. But you can see the reason why, right? That in that survey, 74% of respondents thought that a convention would encourage mediation and conciliation. But I strongly encourage this paper, and it's not difficult to Google. You can't click on this link, but for those of you who don't know, Stacey Strong is I'm a big fan of hers. And if you haven't listened to her, the way she's like a train, runaway train when she presents. Her thoughts just come flowing through everywhere. So if you have a chance to maybe go on the YouTube after this and listen to her, I guarantee for those of you who like, professors who are just rolling out all their thoughts at 150 miles an hour, she's the person to go to, right? Stacey Strong. Here's another piece of data that helps to instruct, inform, and guide us. The Global Pound Conference. And the Global Pound Conference, or GPC in short, was born out of an initiative by the IMI. And the IMI in the mid 2015 or so thought that it would be helpful to revive the history of the Pound Conference and poll the practitioners around the world on concepts such as multi-court corridor, for example, the idea of ADR, what does it mean to your jurisdiction, how ADR can be practiced alongside the adversarial process. But you'll see that when I compare the outcome of the GPC in Hong Kong, in Singapore, and the global. Why global? Because the GPC actually worked its way around the world in many cities around the world. But in Hong Kong and Singapore, there were separate GPCs, and you see that in all of this, what is achieved by participating in a non-adjudicative process like mediation and conciliation? The respondents believe the most important reason is reduce costs and expenses. And the second reason is retain control over the outcome. This second question, to me, is also very instructive, because the question is, currently the most effective dispute resolution process usually involve which of the following, and then you can see the different answers. You'll see that the global accumulated data, respondents said the top most effective dispute resolution process is where you combine adjudicated and non-adjudicated processes. And I think even today, if you were to go out and poll a lot of lawyers, at least the lawyers I know in the common law world, a lot of them will say, well, mediation works well by itself, but it works even better if it's running alongside a adjudicative or adversarial process, such as arbitration, litigation, or even binding neutral evaluation. In other words, that those adjudicative process provides a form of BATNA to the mediation. Because the question we always ask in mediation or even just negotiation, right, direct negotiation, is the question that relates to a alternative. What if you don't get an outcome that's satisfactory to you? What would happen next? And those of us who are familiar with the 7 elements would know that beyond talking about interest, and from interest you derive your options, and from options you weigh that against your criteria, but you're not home yet, because then you say of the best options that fulfill all the criteria that you set up for both sides, you then weigh the best option with the alternative. And the alternative for mediation, a lot of times, is always going to be, if we don't settle that mediation, what would the endpoint look like in litigation or in arbitration? And hence, you can see the data coming out this way, which I think vindicates a lot of the research that anecdotally we have done, even prior to the GPC. This is another piece of data that's often referred to as to why mediation is so relevant to the dispute resolution world today. It's from an article that appears in the Contemporary Issues in International Arbitration and Mediation. The data itself is not novel, but you will see here data relating to a $25 million dispute that's facilitated by ICC. And what's important when you look at this is to compare the two things, which we always say are the reasons why mediation has an advantage over either arbitration or litigation. The first is the cost of the process. And you'll see that, in bold, almost like 2/3 down the table, total cost of arbitration with a 3-member tribunal is about 2.8 million US. Total cost of a one mediator is so much less, right? I mean, you're looking at hardly any cost, 120,000. And then you think about not just cost, but time. Hearing time for arbitration is, in this particular example, 1 week. And hearing time for mediation is 2 days. And in some cases, a lot of cases, I would say, at least in my jurisdiction, a lot of the mediations, however complex, are resolved in 1 day. And when I say resolve, let me be clear about the term, right? Because there's a need for, I suspect I'm preaching to the converted here. Mediation is successful not only when you have a full and final settlement, right, of all the issues. Mediation can be equally successful when parties don't settle, but they leave the mediation having a better understanding of each other's side, and they leave each other knowing that there are things they need to think about in order to get a good outcome, right? Like what Professor Christopher Moore says in his book, the triangle of satisfaction involves not just a full resolution of the dispute, but also the process fairness must be a process that's fair, mediation process being fair to everyone, as well as psychological satisfaction. And in his analysis, the triangle of satisfaction, as long as 2 out of the 3 requirements are satisfied, Professor Moore's data shows that people will say it's a successful mediation. But this particular table, I think, recognizes the fact that mediation carries so much more advantages when it considers both the time required as well as the cost required. this leads us to, I think, what when you think about what happened after Professor Stacey Strong put that data out, is there was a proposal by the US delegation that a working group should be convened to consider this. And so Unshi Trao delegated the US proposal to Working Group 2 for discussion at its February 2015 session. And for those of us interested in history, you will know from reading this that the Singapore Convention did not start well. In fact, on the first day, the chair didn't think that there was much prospect of working on this topic, and it could have died there and then. But why it didn't, it just, peter off and not sort of stop there, was, I would say, I put it to the vision of a dear friend of mine who is a Singaporean, how would you put it, practitioner, but she's a Singaporean officer from the Ministry of Foreign Affairs. Her name is Natalie Morris Sharma. She was elected as the chair of Working Group 2. And from the time she became the chair, she systematically unraveled all the important information that resulted in parties willing to sit down with her and negotiate the issues to resolve the impasse on which the Singapore Convention turns on. Right, so you can see now there 5 of the difficult issues were resolved during her term as the chair of the Working Group 2, which leads us then to a stage where eventually the convention was adopted in the end of 2018, and then it was open for signature by all states in Singapore in 2019, and thereafter it was then the convention papers were brought to the UN headquarters for other countries to sign when they want to. The status as at 2023 was 55 signatories and 11 parties who ratified. I want to show you some pictures, but then circle back to tell you what does the data look like in terms of signing and ratification as of today, right? But the pictures sometimes tells a thousand words, right? So you can see this was the day of the signing of the Singapore Convention in Singapore. And many people, I think, even in our group here, I think some of you may have been in Singapore during that time, where you can see on stage here formal address by the Assistant Secretary Manager for the Legal Affairs of United Nations. And then one by one, the delegates from each country came up to sign the Singapore Convention. That lovely flower you see there is an orchid that's called the Singapore Convention orchid. And I've been trying very hard, Andrea, to buy this orchid, but I can't, it doesn't seem to be on sale. But if I ever find one, next time you're in Paris, I'll bring one for you.
Oh.
But it is a lovely, lovely plant, right? Don't you see? The flowers are just of that color. That's so brilliant. But this is a special orchid design and called the Singapore Convention orchid. But it was a day that was filled with joy by a lot of us mediation practitioners because, and a lot of us were texting each other to say, wow, which country is coming up next. It reminded me of the kind of spirit and environment that football fans will know this, right? During the World Cup, when you have different countries coming and then, every time a country showcase its flag, you do the rah-rah and you feel so excited. That was what the signing in Singapore, the Singapore Convention actually felt like. A closer look again at the convention orchid, and right in the center, that gentleman is the Minister of Law then, Minister Shanmugam. The whole group of signatories and country representatives that day, and right in the center next to the Minister of Law is our Singapore Prime Minister then, Mr. Lee Hsien Loong. This is when the then Minister of State, Edwin Tong, deposited Singapore's instrument of ratification in February of 2020. And so those were the picture highlights of relating to the Singapore Convention. But the words I think that you can see on screen, I think is instructive of how Singapore, as the country having the benefit of naming rights, saw the convention, the words of our CJ Sundaresh Menon, who says that the adoption of the Singapore Convention heralds a new era for the resolution of cross-border commercial disputes. And he compared this to the New York Convention, right? Just as New York Convention did for arbitration in the 1950s, this convention will unlock the potential for commercial mediation by removing what has been its greatest obstacle. The obstacle being, as you will recall from the earlier data in the earlier survey, that people said, without a convention that allows enforcement of cross-border mediated settlement agreement, we do not think mediation is worth embarking on, right? And he uses this phrase, which a lot of us use now, that the sun will rise upon a new golden age of international commercial mediation. Such lovely words. And I hope that, later on when we think about the pros as well as the con, that we won't be jaded by the fact that, it is a golden age. And I hope that the golden age will see a lot more countries signing and a lot more countries ratifying. Very quickly, let's talk about the what. I don't want to belabor the point on the what because if you go to the UNCITRAL's website, you will see the convention papers there, and you can certainly read the convention for yourself. It's a short piece of instrument, not difficult to read. But here's the data I wanted to show you. This is from today. And you will see that right off the website of UNCITRAL, the number of parties who ratified is 20, number of signatories is at 59. And if you go to the website, you will see below that who are the countries that have signed and who are we waiting to sign and who are we waiting, who are countries who have signed but not yet ratified. When we look at the convention and the details of the convention, it's important for us to know what the scope applies to, and immediately you will see off the bat, it obviously applies to commercial cases, commercial disputes, which means it doesn't apply to consumer issues, family inheritance, employment law is outside the scope of the convention, right? And the convention has to relate to disputes that are, or agreements, mediated settlement agreements that are international in nature, right? And international is defined. But bearing in mind just that we don't get so confused by the terminology, right? The mediated settlement agreement, of course, it's agreement that results from a settlement during the mediation. It is not the agreement to mediate, right? Hence, the definition MSA does not refer to the mediation agreement, which is what people enter into just before they agree to mediate the dispute. The definition here of mediation is purposefully broad. And so they may use terminologies that you may not use even in your own statute at home. But you will see that it says here, irrespective of what expression you use, on the basis of which the process is carried out, a mediation would satisfy the convention definition as long as it had these characteristics. Attempt to reach an amicable settlement by the parties with the assistance of a third person, right, a neutral person, right, who lacks the authority to impose a solution or outcome. That's the definition. And it doesn't matter what remedies the parties choose, but whatever they are looking for, as long as it fulfills this definition, will fall within the convention definition of mediation. There are three very simple form requirements. The agreement must be in writing, the agreement must be signed by the parties, and there must be evidence that the settlement agreement results from mediation and not from direct negotiation. So for that purpose, you must have either the mediator's signature on the settlement or a document signed by the mediator saying the mediation was carried out, or attestation by the mediation institution, or some other evidence acceptable to the competent authority. Who is the competent authority? Right. The competent authority typically refers to the enforcement authority in the country in which you are seeking to enforce the mediated settlement agreement. So if you have a MSA that you concluded, let's say, in Paris, just because we were from there recently, and you wanted to enforce that agreement against the party who you know has assets in Singapore, you would then enforce this in Singapore. You'll come to Singapore, file an application before the competent authority. Who is the competent authority in Singapore? The Supreme Court of Singapore, right? So that's quite straightforward, right? And in some other countries, maybe the competent authority would not be the courts, but as far as I know, in all the ratifying countries, the courts have been the competent authority. There are 11 grounds for refusal given to the competent authority not to allow enforcement of the mediated settlement agreement. And many of these grounds, if you're familiar with the New York Convention, you would say nothing new, because a lot of these grounds mirror the grounds, the vitiating grounds in the New York Convention. So I won't belabor the point, except to point two, where they are novel and very bespoke to the Singapore Convention. Article 5.1, E and F. These two particular grounds for refusal is particularly not just novel, but perhaps for some of us controversial, because the attack in this two is in relation to standards for the first, and the second, failing to disclose circumstances that affects the mediator's impartiality or independence. So when you look at Article 5.1e, it provides that it can be a vitiating ground for a party, and a vitiating ground is when a party goes to the court as a defendant and say, judge, you should not allow this mediated settlement agreement to be enforced against me or my assets, because I can show you that this ground is proven in this particular case. And when you look at Article 5.1e, the defendant would say, I can show you that during the mediation, the mediator failed to act according to standards which are applicable to the mediator or standards applicable to the mediation as a starting point, right? And the debate for a long time, many years now, has been, what standards are these? Are these localized standards? So in the example I gave earlier, if you were enforcing this mediated settlement in Singapore, and you said the mediator, let's say, was in Paris doing his or her work, what standards applied to that mediator who mediated the case in Paris, right? And you can think for yourself immediately that there's a whole host of potential complexities when you think about it that way, because short of those standards being already pronounced in your agreement to mediate prior to your mediation. For example, in the agreement to mediate, the mediator says, I will be mediating according to the ethical conduct rules of the Singapore International Mediation Center, for example, or I will be mediating according to the codes of conduct of the International Mediation Institute. But short of that being set up in the agreement to mediate, it would be for the defendants to plead what standards are applicable, and then for the applicant to say, well, those are not the standards, or if those are the standards were complied with, right? And so you can see that the dynamics of this has resulted in quite a number of people holding the view that this is extremely controversial, and therefore the country they belong to should not ratify the Singapore Convention, because this would expose the mediator to potential liability. The other thing that we have to note from Article 5.1 and Article 5.1F, E and F are the words without which, right, for both E and F. And what this means is that not only must you show that there was this failure, you must then also go on to show that even if this failure itself led to a party doing something which they would not otherwise have done. Right. So it's a double negative that you need to consider. Now, for example, Article 5.1e, right? The failure by the mediator to abide by certain standards as a mediator. Say the mediator failed. But despite that failure, that breach, did that breach result in the party entering the settlement agreement? That means if that breach had not taken place, would that party still have entered into the settlement agreement? Right? It's a postulation, not easy to answer. And the reason why this is there is because if you ask the drafter of these two statements, someone that a lot of us would know, Michel Kalipatis, KC, it is because he believed that in a lot of these international mediations, parties will be represented by lawyers. And it will be extremely unlikely for a party represented by counsel, for the counsel to allow the mediation to continue, even if the mediator had breached certain standards or codes of conduct. So a situation where Article 51E or 51F arise in the context of those words, I think would be unlikely in international mediations as we know it, right? Okay. The rest of the vitiating factors, again, as I said, are very close to what the New York Convention holds, so let's not belabor the point. Let's go into the consequences of the convention. What if the convention applies? For that, let's use a quick example, right? Moving away from Paris, right, Andrea? Let's look at something closer to my country. You have a company A, let's say that's a supplier of cell phones, and that company is based in Delaware in the US. And let's say that you have a company B that's a Singapore company that distributes these cell phones. And both countries had a contract for the supply of the mobile phones. Dispute arises. Company A, the US company, commenced action against the Singapore company. But before the case went to trial, both sides agreed to mediation. They decided that they will go somewhere else other than Singapore to hold the mediation. They decided to go to Thailand because Thailand has lots of nice beaches. It will probably appeal to a lot of the parties, maybe as well as the mediator, right? And maybe because they were in the beach mediating, nice environment, a settlement resulted. And then under the settlement, Company B, the Singapore company, agreed to pay the US company $500,000. So those are the facts with background. You can see that if you look at the small map of the world, there are three potential countries that have been triggered by our discussion. On the extreme left, the Delaware company based in Delaware. Extreme right arrow, the Singapore company. The center red arrow, where the mediation is carried out. Which of these three arrows, as you're thinking, are pertinent or relevant to the Singapore Convention, do you think? And let's move on with the facts, right? So a breach took place. Company A, the US company, now wishes to enforce the mediated settlement agreement. And all of us here, right, you've been instructed to act for the US company. What are the issues relevant to company's A's claims? Assuming the client asks you, can I not enforce it under the Singapore Convention? How would you apply the Singapore Convention? Going back to this particular model again, right? And let's make some assumptions, right? What if the assets are based of company A, the Singapore company? Let's say the Singapore company, in Singapore, there's only a holding company. Its assets are not there. Let's say that its assets are based elsewhere. Let's say in China, right? Does it matter? How do you apply the Singapore Convention? Do you have to find the seat of the mediation, just like you would in arbitration, right? What procedural rules or laws would apply? How would you apply your application? And I want to just leave it hanging there so that you can kind of see how things might be different or similar to the application of the New York Convention. And we'll circle back to this if we have time during the Q&A, right? So let me close then with leaving that question hanging there, and we can revisit this, but arguments for and against the Singapore Convention, because, a lot of us are very much for. I have a lot of colleagues in Singapore who are very pro-Singapore Convention, and a lot of good reasons, but I'll just name three. It addresses the reasons for users' reluctance, as we can see from all the data and survey that we earlier on discussed. And of course, there's evidence of the success of mediations, and hence a convention that deals with this would encourage people to mediate even more so, right? And of course, enhancing the use of mediation internationally, because now there is a convention that deals with mediation. But what about the arguments against? And this comes from a lot of mediators. A lot of them, I would say, are very how do you say, they are very vocal about these arguments. Some of them are our friends, Andrea from the US, right? Should you even have a sui generis instrument that is nothing more than a mediated settlement agreement? Why do you elevate a mediated settlement agreement? There's really nothing more than at its roots a contract simpliciter. Why is this particular contract so special that in and of itself it can be enforced as of right? Right. And then the other concern raised by a lot of American practitioners is they do not want to attest to an MSA. The American mediators do not have a habit of attesting or signing against a mediated settlement agreement. And of course, they do not, and this applies not just to the Americans, but many mediators around the world are extremely concerned about the refusal to enforce based on mediators' conduct and standards. Which then brings me to my own personal reflections. Well, I think that at the end, what I think is good about the Singapore Convention, it actually does address the objections against the use of mediation, and it does renew the focus on the use of mediation, especially since the signing and the coming into force of the Singapore Convention. You now find that the ISDS, right, the investor state disputes, have hopped on this bandwagon and started to latch on to the utility of the Singapore Convention to encourage people to use the mediation process for investor state disputes as well. In this space, we know that, for example, ICSID has been going its rounds, changing its mediation rules, moving away from just straight conciliation and encouraging parties to attempt mediation, even for investor state disputes, right? And of course, as a convention, it enhances the standing of mediation. But I think the downside is that we might have to wait a bit more time because the way the convention work is that the application is against the state that's ratified. And because right now, if you look at all the states that's ratified, China has not ratified, the US has not ratified. And when you think about the large economies not having ratified, well, others, other states might just play a holding game and waiting game, because why would they sort of allow people to enforce a mediated settlement agreement in their jurisdiction when they don't have that reciprocity in the large or the largest economies, right? So that quid pro quo is maybe what troubles some people. And not to mention, a lot of people, of course, remain very skeptical. In fact, the difficulty that some of us face is that the champions of mediation, right, worldwide, have been very slow on the take-up. In my part of the world, Asia Pacific, you think of the Australians have been the proponent at the forefront of mediation for the longest time, but for a long time, they were laggards in signing the Singapore Convention. Likewise, New Zealand. Right. But those are issues arising from, I think, I suppose you could say that the divergence in interest between the state and mediation practitioners. And then, of course, issues relating to mismatch of supply and demand. So this again is a quick primer and maybe just a quick roundup of what I think are the important things to think about on the Singapore Convention on Mediation. This is a logo, and it looks very much like the orchid that you see. And certainly, if I ever get my hands on the orchid, Andre will be the first one to hear from me. So on that note, I'm going to stop share and hand this back to you, Andrea.
Thank you so much, Ted, and I'm looking forward to it. Okay. That was so insightful and a lot of information. And I'm looking around and looking to all of you. Most of us are mediators. And I feel there was one point that was especially interesting to me, and that is that the emphasis on the conduct of mediation, right? And I feel that there is a huge emphasis and also like a risk coming and unclarity coming with it about the conduct of mediators. But on the other hand, there is not really a definition about it.
Mm,
Am I right, Ted? That would be my
absolutely right.
point. And then I
Yeah.
open the floor for everybody and also hand over to you, Ian, to facilitate it. Yeah, yeah. But my
Okay.
question would be just this was, would you say that there is a clarity about the conduct of mediators that is given from the Singapore Convention rules or statutes, or is there unclarity about it?
I think that what has happened is the word standards has opened up a big discussion about what that word actually means.
Hmm.
And for some, it means that if you're a mediator that are in the panels of a few, say, ADR institutions worldwide, might you then be subject to all the codes that each of those institutions require you to comply with? And on top of that, supposing you're a Singapore lawyer who is mediating a case, you would likewise then also have to comply with the codes of ethics of you as a Singapore lawyer. And so you can imagine that a single person coming to mediate a case, he might be dragging along a whole stack of different codes and standards where the moment those codes, any one of the potentially, let's say, three or four sets of codes are triggered, it gives an excuse for the defending party to say, there we go. That mediator has not complied with that code, and therefore this particular article has been satisfied. Of course, we haven't yet considered the without which question, right? But it does give a chance for a defendant to raise a vitiating factor against enforcement.
Thanks,
Yeah,
Ted.
complex. Yeah.
Well, we've got a number of questions about commercial mediation, a few other things in the chat. We'll come back to those later. What I want to do first is open up the floor to any other questions specifically about the Singapore Convention. Sorry, you had your hand up earlier. Sarah?
Oh yeah, sorry. Hello everyone. Hello Ian, Tat. Nice to see you again. We met in
Likewise.
Vienna. Yeah, we met in Vienna twice.
Yes.
Something I've learned, I think, when I started doing my master's about international commercial and corporate law is the old tale of like convergence and how hard it is to harmonize national laws, and every country is trying to protect their national laws and court systems. Would you say that we could rely also on market pressures and business corporations who choose to mediated settlements to kind of get governments to listen and understand that, hey, the market pressure, the business pressure, they're demanding mediation could help ratifying and countries and governments to enforce the convention in their systems?
Yeah. So my learning has been that right from the time when Working Group 2 was in progress, that to my surprise, and perhaps looking back, I shouldn't have been so surprised, that governments and government representatives who are participating in Working Group 2, many of them were very confused about what mediation was all about. And quite a
Hmm.
number of them actually have no idea what
Yeah.
mediation is. Many actually thought that it was a kind of arbitration. And so
Hmm.
when they went into a discussion, often you find that the reason why they could never quite appreciate what was being discussed by the mediators who provided assistance was they keep thinking, but no, that there's a mediator would impose a solution, right?
Hmm.
And the mediators keep explaining, no, that's not what mediation is.
Hmm.
So part of the learning I've had is that in many countries that realize that this is a problem, they have enrolled the assistance of the professional mediators to work alongside the government representatives. And there's a little bit of capacity building that goes on in a lot of these forums where the government representatives are willing to sit down with mediators to say, tell me more about actually what this process is all about.
Hmm.
And under what circumstances, what space, what landscape does mediation take place, and when is it effective? When is it not as effective? What does the process like? What's the onboarding? All of those things that we talk about, right, during our journey in learning about mediation.
Mhm.
Well, I think as much capacity as you can provide to government representatives, and I think they reach a point where they appreciate why the world, or at least half of the world, are so enamored by mediation,
Hmm.
and the other half is either ignorant or just resistant to coming alongside.
So a knowledge that removes uncertainty about the process and about mediation.
Yeah,
Okay,
that's
thank
right.
you.
Thank you, Zara.
Okay, we have any other questions on Singapore Convention? We have one question in the chat specifically about commercial disputes. And the question, Tat, is which style of mediation do you think is more appropriate for commercial disputes?
Yeah. Well, I think a lot of us probably will have an answer for this. All of us here who have been doing mediations, and I think, if I'm not wrong, if we were to poll most of us here today, the majority of us will say, well, there isn't one singular style. And as unsatisfactory as the answer would be, it will be those two words, it depends, right? But what does it depend on? I suspect it will be the nature of the dispute, the parties coming before you, whether they are legally represented or not, and perhaps the country you come from and how mediation is either well received or still in its nascent stage. But all things being equal, my preference, I think, would be that for commercial mediations, one should start with facilitated process. Because in fact, facilitative offers probably the widest scope for parties to find their own solution. And when you think about the other spectrums of mediation styles and modes, one thinks again about, quite rapidly evaluative mediations, one thing about transformative mediation. You could have bits and pieces of those coming in alongside facilitative, but again, in the mainstream commercial mediation world, I think most commercial mediators would start at least with facilitative and either remain there or at some point incorporate parts of transformative or evaluative mediation. The other debate, I think, in that space, what style, is the question that is no longer novel, right? People talk about should you have joint sessions only or caucus only mediation? And I mean, it's quite a dated discussion, right? But I find that even in today's environment, people still talk about that question. But I think it's safe to say for those of us who might be keen on that question, it seems to me that there are certain kinds of cases, and cases also been administered in the US particularly, that the mediator sometimes prefers a caucus-based mediation, where parties may not even meet. Whereas in a large part of the world that I belong to, particularly where it relates to relational disputes where people have problems in relationships, where the source of the conflict is relational or interest-based, and maybe less about structure, less about values, less about emotions, that maybe it's more appropriate than for evaluative mediation or something that the mediator can express themselves.